dispatch of business. God save the state and this honorable court.
Good morning. Thank you for your flexibility in allowing us to move the case forward a bit. Case being Kluttz-Ellison versus Noah Playloft Preschool et al., and we will hear from the appellant.
Good morning, Chief Justice and Associate Justices. If it may please the court, my name is Lindsay Weichel with Hedrick Gardner out of Charlotte, North Carolina. I am going to be representing defendants in the case before you today. The Industrial Commission can only award medical treatment that is directly related to the original work-related injury. This direct relationship requires causation as mandated by our case law. Plaintiff's gastric bypass surgery is not directly related to the original workplace injury, so it is not medical treatment that can be awarded under the Workers' Compensation Act. The full commission and the Court of Appeals ignored the requirement that the medical treatment awarded must be causally related to the compensable work-related injury. Plaintiff's obesity was not caused by her workplace injury. Therefore, there is not a direct relationship between the workplace injury and her gastric bypass surgery. Just because her obesity prevented her from having the right knee surgery does not mean that defendants, the employer, now needs to pay for treatment for the obesity. The full commission only used the definition of medical treatment under 97-219 in finding that the treatment must be required to effect a cure, provide relief, or lessen the period of disability to award the gastric bypass surgery. They missed that crucial link of causation that is needed for the medical treatment to fall under the Workers' Compensation Act. A direct relationship or causal relationship between the treatment and the compensable injury is what allows the treatment and allows the Industrial Commission to award medical treatment. Plaintiff's counsel.
What you're proposing, though, is more than just a causal relationship, right? Because one of the well-understood forms of causation is but-for causation. It's a rudimentary form of causation, but it is the one that the Court of Appeals seems to use here. They have these two sort of confusing standards they apply, but one is connecting the dots, and then the other is but for this would not have happened. And the but for is but for the fact that you need to do the knee surgery and it needs to happen quickly. The doctors would not have said, well, then you must have the bariatric surgery. So why isn't but for causation the use of causation here in this case?
Because the but-for causation is used in civil litigation, and in the for the Workers' Compensation Act, it's a compromise for plaintiffs don't have to prove negligence or intention or at fault. The employer is automatically required to pay for the wreckage of their industry. And so there needs to be a direct causal relationship, and that's why they say implicit in the authority of the Industrial Commission to award medical treatment is the fact that it be directly related to the original injury. And so it's not a but-for standard because there's a compromise that is essential in the Workers' Compensation Act between employers having determinate liability and the employees getting benefits and treatment for that workplace injury. So that direct causal relationship is key to any benefits being awarded under the Workers' Compensation Act.
Where doesn't the statutory language, though, consistent with the common law, we take someone as they are in civil cases, right? Wouldn't the legislature have needed to indicate an intent that, and something different than the language you cited with respect to effect a cure and give relief, wouldn't they have had to do something more to say, well, if you're, whether it's someone because of age or disability, or in this case, weight, you took them as they were when you employed them, and under the workers' comp statutory structure, we as the court need something more from the legislature to impart something that's not in the statutory language, taking us out of the common law civil scheme. Do you see what I'm saying?
Mm-hmm. And I feel that's found, and defendants feel that's found in 9725, which is directing what medical treatment can be awarded under the Act. And there's the legal standard that states in our case law, implicit in the authority for the Industrial Commission to order additional medical treatment is that it needs to be directly related to the original injury. And you mentioned the employer taking the plaintiff or the employee as they are. This is true, but if the workplace injury did not aggravate or cause a pre-existing condition to worsen or become apparent, then the employer is not liable to pay for treatment for that pre-existing condition if the workplace injury didn't cause any damage to that pre-existing condition.
So take our current facts and take out the issue of obesity. She'd had a knee replacement already. That injury was, the commission found, exacerbated by her later fall while fall from a ladder screwing in a light bulb. She had a pre-existing condition. She was employed under the workers' comp statute. The employer's liable to help fix an injury that comes on the workplace, aren't they?
Yes, because the direct relationship is there. The fall was found to cause the loosening or aggravate the loosening of the hardware that was already in her knee. Here, there was no findings showing that the workplace right knee injury caused her obesity or increased her obesity. In fact, she actually lost weight after the workplace injury.
Well, I just want to follow up on the commission made a finding of fact that the bariatric surgery was a medically necessary prerequisite to undergoing the right knee replacement. So just following your logic that under the workers' comp statute, it's the employer's obligation to pay for the wreckage of their industry and the injuries that the employee might receive. Here, if the bariatric surgery is a medically necessary prerequisite, if it's not covered, then she's not going to get the treatment that she needs for the injury that she sustained on the job.
Your Honor, I would say that the injury on the job did not create that barrier that is her obesity and her weight that is not allowing her to get the surgery. Regardless of what surgery or what caused a need for a joint replacement, her obesity would have prevented that regardless of whether it was at work or not at work.
But I guess my point is, by failing to cover the surgery that she needs in order to be able to have surgery on her knee, then you're preventing her from being able to have surgery on her knee.
And I would say for the Workers' Compensation Act to be applied, it's not supposed to be general health insurance. And if she is unable to get the surgery under the Workers' Compensation Act, this would then fall into the General Health Insurance Act. And the Workers' Compensation Act was not supposed to be global general health insurance to be paid for by the employer.
But it seems to me that covering what she needs in order to get the treatment to recover from the injury isn't turning it into general. It's not like she is trying to get a root canal or something, right? It's very clearly found as a fact that it was medically necessary to have the bariatric surgery to undergo the right knee replacement. So she can't recover from her workplace injury without this. And I guess it seems to me that if we go down the road of, just getting treatment for the, that there's some elements of treatment you get if it's something you need not caused by the injury, but you still need it to recover from the injury, you could start parsing out all sorts of elements of medical treatment and say, well, you need the anesthesia because you can't tolerate pain, so we're not going to pay for the anesthesia. You could, where's the dividing line?
Your Honor, defendants feel that the dividing line is already put into the case law, and that is that it needs to be the medical treatment needs to be directly related to the original injury. And
right, but you can see how there's some, I hear you on that language, and, I have some questions about whether the difference between it coming from the statute or the case law, but where I'm not seeing the line is, so you have an injury, I'm injured on the workplace, I need crutches. A colleague who, let's say, is 60 or 70, the doctor, same injury, same workplace, the doctor said, well, you need a wheelchair. And the wheelchair's a lot more expensive than the crutches. But taking us as we are when we're injured on the workplace, are we going to start parsing the difference in cost between what a sort of average able-bodied person might incur to be fully cured versus the need for a more expensive motorized wheelchair when the commission is charged with making those factual determinations? I think that's what Justice Earls is getting at, is I'm worried we're opening the door for a lot of parsing on what is medically appropriate, when we get experts to deal with that, and we ask the commission to make the fact-finding on that.
Your Honor, it's not about costs. It's about whether the workplace injury caused the need for the surgery and that direct connection. And you brought up, what if, there's other issues. What if someone has a congenital heart condition and they can't have the knee surgery? If we go with the but-for standard that is in place right now by the Court of Appeals, that would mean that the employer now has to pay for the congenital heart condition to be fixed until that person is able to have surgery in their knee.
But the flip to that is, if someone has an issue that requires like cardiac catheterization before they can have the medical treatment necessary to cure the workplace injury, sorry, out of luck? I mean, is that what you're saying? And I still want an answer on this wheelchair versus crutches example, because I think that's important to me. The injury is the same, it's on the workplace, it's directly related. There's a cost difference or a treatment difference associated with fully effectuating that cure. Am I taking your answer to be there's no issue there, it's directly related, so it doesn't matter?
Yes, if it's directly related and the doctor orders medical treatment, and that could be a wheelchair, that would be covered under workers' compensation. However, a congenital heart condition that needs to be treated or prevents a surgery because having the surgery is too dangerous based on a pre-existing condition that has no connection to the workplace injury is outside of the Workers' Compensation Act.
So I want to ask another hypothetical. Under the Court of Appeals holding, suppose that you're in chemotherapy treatment for cancer, but you've been fighting your cancer. It's a costly chemotherapy treatment, but you've been fighting and you feel well enough that you can go back to your office job. And while at your office job, you have slip and fall. It's a torn, Achilles tendon or something where you need a very straightforward form of orthopedic surgery, but the surgeon says it's just not medically prudent to perform a surgery like this until your cancer is in remission. Wouldn't the employer have to then take over the cancer coverage for the rest of that patient's treatment, something that could last a very long time?
Yes.
Very expensive.
Yes.
That does not seem like the intent of the Workers' Compensation Act. So there must be some line, and what I think this court has to do is just figure out where the line is. you're proposing what seems to me to be proximate causation as a test, which is hard to justify because you can, as you've heard, come up with lots of hypotheticals where that seems unfair. But it seems like the Court of Appeals has gone too far as well with the sort of connect the dots logic, because that eliminates the word directly from the test we created. Any time you connect dots, eventually you can relate something to something else, but it can become awfully indirect. That's the whole point of, if it was direct, you're not connecting any dots because the line goes straight from the first dot to the second. Have you come up with any way that we can make what I think you described as the workable test that addresses all these concerns about the outlier hypotheticals?
Yes, Your Honor. Defendants believe it is directly caused by the injury, the direct causal relationship. So if you would have to ask if the injury, the workplace injury, caused a change, for the worse, caused a harm, and that harm is being treated, that falls under Workers' Compensation Act. However, if there is no causal relationship, direct causal relationship between the workplace injury and the treatment, that is not under Workers' Compensation Act. What the Workers' Compensation Act was created to do was a compromise to give the employers determinate liability, and in return, the employees are given the benefit of being treated, receiving benefits, regardless of negligence, even on their end, whether or not they are able to show there was any ill intent or intentional. So it's a compromise, and the main purpose and the main principle of that compromise is causation. And if you cannot say the workplace injury caused the need for this surgery, which it didn't here, because the need for the surgery is her obesity, and that did not increase or was not found to be caused by the workplace injury. And so you cannot make the employers pay for a pre-existing condition that was not part of their wreckage of their industry. That is.
One more question about that, because I think this is going to be one of the strongest arguments we hear from your friend, which is there's a test that could be created. So let's say, for example, someone has a serious blood pressure problem, and doctors have said, you must treat this, take this medication. And it will, in let's say 6 months, it will lower your blood pressure, but the employee doesn't take that medication. Then they have the workplace injury, and their doctors say, in order to treat this, we have to lower your blood pressure. You can see a test that would say, that's a healthcare problem. Your doctors have told you to do this. You weren't doing it. Your ordinary health insurance needs to pay for you to, and then once it's capable, you'll get what will affect a cure to your workplace injury as the workers' comp system intended. I think what your friend is going to argue is that the difference here is the commission found that although the employee's general physician said you need to deal with your obesity, there were many ways to do it. And what happened in this case is the workplace injury eliminated some of the less risky ways, the ways that sort of less costly and have less of a life impact, and left only one option, which was the bariatric surgery. And that is because the doctor said, we have to get you to lose the weight quickly so we can get to the knee surgery. And that's what makes it directly related versus, a sort of condition where you've had it and you should have been working on that sort of thing. So what's wrong with that argument? That's the direct connection is I lost my choice, now I have to have a life-altering surgery.
Your Honor, if you look through the record, there is no doctor or testimony that stated because of the workplace injury and her inability to, say, do calisthenics or jumping jacks, that she is unable to lose weight. Actually, what the doctor stated, Dr. Commodore, was that it's because of her genetics, her body composition that she had prior to this injury, And the fact that she was so obese and needed to lose a great amount of weight is the reason that they recommended the gastric bypass surgery. It actually did not have anything to do with the workplace injury or her ability to exercise. In fact, Dr. Commandal mentions how 75% of weight loss has to do with diet and genetics, and I believe Dr. Malako even takes it further to say 90% is genetics and diets. There is nothing in the record that states the reason she needed the bypass surgery is because of the workplace injury.
What I was referring to is, I want to find, in finding of fact 24, the commission says, so I think Dr. Barrier is the general physician, says, it would be healthier if plaintiff did lose the weight, but the emergent requirement for the loss of the weight derives from her need for a total left knee replacement. So I interpret that to mean your general physician is saying you need to lose the weight, but you don't have to have bariatric surgery right now. There are other options. And then you have this knee surgery you have to have. Now you have no options. You have to have the surgery.
Your Honor, in fact, that's not what the Dr. Barrier stated, and in the record, and we mentioned that we disagreed with finding of fact number 24 because Dr. Barrier actually does not say that. He states that she needed to lose weight. She's been trying to lose weight for 20 plus years before this. He actually prescribed her phentermine. She was a candidate that was diagnosed with ability to have medical weight loss prior to this injury. And Dr. Barrier, he is deposed after this injury and asked a question by plaintiff's counsel whether she needs to have this surgery, and he simply states that she needs to have the surgery because that was recommended after she was recommended the right knee surgery. And the doctor who actually recommended the right knee surgery, Dr. Commandal, and referred her to the medical weight loss, did not say it was for surgery. He said she needs to lose weight because it's going to kill her. And he said in the long run, if she loses enough weight, then she can have a revision surgery down the road. So there was no emergent, as in meaning emergency, for her to have this gastric bypass surgery, to have the right knee surgery. And Dr. Commandal did not state that it was an emergency, and he did not know whether or not she was going to be given a diet plan or referred for surgery.
Can I also ask you about finding of fact 35 then? Do you also dispute that? That's where the commission finds that based on the preponderance of the evidence in view of the entire record, including the testimony of Dr. Malako and Dr. Barrier, the full commission finds that the bariatric surgery plaintiff underwent prior to April 25, 2019 was medically necessary to achieve the BMI of less than 40, a prerequisite to allowing plaintiff to undergo the revision. Right knee.
Your Honor, I do not disagree that her bariatric surgery was found to be medically necessary for her to get to a BMI of less than 40. What I disagree with in that is that the medically necessary does not relate back to the original injury, which is her right knee. It was not a medically necessary, her obesity needed to be treated. That's what was medically necessary with the gastric bypass surgery, not anything dealing with the right knee injury.
So you disagree that it was a prerequisite to allowing plaintiff to undergo the revision of their total right knee angioplasty?
No, Your Honor, I do not disagree that it was a prerequisite, but whether or not that prerequisite is related to the original injury is where we disagree. If there's no further questions, I'd like to reserve the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Thank you, Chief Justice. May it please the court, Chief Justice and Associate Justices, I'm David Shelby from Salisbury, North Carolina. and I represent the appellee, Ms. Robin Kluttz-Ellison. In this case, bariatric surgery is required to treat the compensable injuries. Without payment for the bariatric surgeries, the defendants would be relieved of their responsibility to treat what is an admitted compensable injury in this claim. It would not restore the injured worker to their health, would not allow the injured worker to recover and return to work. The key here is that if it wasn't for the knee injuries in this case, the plaintiff would not require the weight loss surgery or to lose weight. I think in the hypotheticals that have been somewhat discussed here, that's sort of the distinguishing factor. Justice Dietz mentioned the congenital heart condition, I believe. And this is not a situation where someone is living with a congenital heart problem and they don't need surgery for it. They don't need treatment for it. Prior to this injury, she was living with a weight problem. I don't think any doctor is going to dispute with them when someone's obese, losing weight would be helpful. But Dr. Barrier, the treating physician, said, wow, yeah, it would have health benefits. It's not required. And in this case, in the example of a congenital heart condition, if someone is living with that condition and treatment for it is not required until after the work-related injury, but then after the work-related injury, treatment is required, then that's not branching out into the field of general health insurance. That is causing the defendant to pay for, to use the terms in the Workers' Compensation Act, the wreckage of industry, to pay for what they caused. In the scenario the defendant suggests, in the test that the defendant suggests, the defendants would be relieved from liability. If the plaintiff could never lose weight, then the plaintiff could never have the surgery. And the defendants would not have to pay for admitted, at this point, compensable injuries to the plaintiff.
But can you see how your friend's argument, as I understand, is essentially this, that if you were to describe to someone the idea that you have this employee, the employee is obese, the employee has a workplace injury, let's just simplify it, and has a injury at work and has a severely injured knee, needs knee surgery. And then once the doctors are examining how to do the knee surgery, realize the patient's BMI needs to be lowered to a certain level. In order to do it, we think bariatric surgery is the approach to that. And then you were to say to this person you're describing the scenario, what is the relationship between these two surgeries and the workplace accident? It seems reasonable to say, well, the knee surgery is directly related to the workplace injury, and the bariatric treatment is indirectly related. It's not directly related. It is related, but indirectly in the sense that this isn't a condition caused by the workplace accident. It's just one that needs to be treated in order to treat the injury that's the main one that resulted from the workplace accident. And so that's what makes it indirect. If we don't say that, there are no indirectly related injuries because there's always going to be a relation. So what's your response to that argument? That the key to this case is the word directly, which was chosen by the courts.
Well, I think it's in the case law. The Pittman versus Thomas and Howard case says medical treatment must be directly related to the compensable injury. So I think the Court of Appeals was using that language out of Pittman. But directly related, I mean, using the ordinary meaning of the words, direct means, and I love this definition for this case, to move, point, or extend, project towards a specific line.
Right. I noticed that I figured you probably like that definition because what a statutory constructionist will point out, you chose to define the verb to direct, not the adverb directly, which if you look at its definitions are slightly different and not as, I think, favorable for you. I mean, how do you address the fact that just in ordinary English usage, if I was to tell my law clerks, I'm going to leave the building here, I'm going to go directly to the state capitol, and then I went outside and I went and got a cup of coffee and went over there, I didn't go directly there. The idea is that you can just draw the line, and if you connect the dots, you're not drawing the line. You're getting there, but perhaps indirectly, not directly. And I think that's your friend's argument is
Well, and I
that's what
think
the
it
word
goes, I'm sorry, Your Honor.
No, go
I think it goes to the rest of the phrase, related, connected by reason. And this is connected by reason. And I think the reason the reason the Court of Appeals talked about this but for is, why is it being done? And that's the direct relationship. The defendants in this case, to me, seem to confuse concepts. And what I mean by that is, the plaintiff is required to show that the injuries are causally related to the employment, which she has done and is no longer in dispute. And what they seem to want the court to do is create a situation where every time treatment is recommended, they've got to come in and reprove that causation again. And I think that there's a second part. Once you've proven causation, that the knee injury is related to the employment, then the question becomes, and it's a question for the commission under the law, what treatment is directly related? And the courts have held that what treatment is directly related to a compensable injury is within the sound discretion of the commission, and is within the commission's discretion, and is not disturbable on appeal absent abuse of that discretion. And I can foresee, depending on how this case moves forward and how it comes out, a situation where the appellate courts are now required to address this issue again and again and again. If the example that was given by one of the justices, I think it was Justice Earl, what about the anesthesia? Is it directly related? Could a human being undergo the operation absent anesthesia? I mean, are the appellate courts going to get into the business of deciding those issues? Or are they going to leave it to the industrial commission as long as it is within the sound discretion of the commission and it is not an abuse of discretion to decide those issues, which is the way the compact envisioned it and the way it was set up? I mean, cost containment is not the sole purpose of the Workers' Compensation Act. The purpose of the Workers' Compensation Act is also to restore a worker to their health and allow the workforce after injury in the state of North Carolina to continue to work and be productive members of society. In this setting, and the point was made, in this setting, if she does not have this surgery, they do not pay for the injuries that they admit are related. They do not pay for the surgeries. The worker never has those surgeries. The worker never returns to health and employment. And doing so...
But the employer stands ready to pay for that. I mean, isn't that kind of why it's not quite as bad as it sounds? I don't think the employer in this case is saying, I'm not going to pay for the surgery. The employer said, we stand ready to pay for it. We want you to get this treatment. You have another condition, like everyone else in America, go get your health insurance or however it is that you're going to pay for that, get it done, and then, we look forward to you get it better.
But easier said than done often, Justice Dietz.
But not a problem. I agree with you about that, but perhaps outside the scope of workers' comp to solve that problem.
Well, but if there is that but-for relationship between what the injury is and what treatment is needed, then you continue to keep it outside of general health insurance. It is not, I got injured, now pay for everything. It is, I got injured, now pay for what is necessary to treat those injuries. Not pay for my root canal, as one of the justices mentioned. Not pay for my teeth being capped. It's not general health insurance. It's pay for what is necessary to restore my health and allow me to return to my pre-injury condition to the extent possible.
So in my hypothetical earlier, do you think the employer and their workers' compensation carrier take over the cancer treatment for the patient that can't get the surgery till they're in remission?
No, Your Honor. I think there's a difference there.
What's the difference?
The difference is, in the first hypothetical you gave, where there is a congenital heart defect, if that person is living with that congenital heart defect without the need for treatment, then I think the answer is, if you need the treatment to have the workers' comp surgery, then the employer has to pay for it. In the cancer setting, I think the hypothetical is different, because I can't imagine a doctor saying, your cancer only needs to be treated because to have this workers' compensation surgery. In that hypothetical, I assume the cancer needs to be treated whether or not the surgery is required in the workers' compensation setting. So that would be sort of the line I would draw. I don't think you can apply that but-for test under those circumstances and say, but for the workers' compensation injury, the cancer does not need to be treated.
You're arriving close to where I was arriving and trying to wrap my head around this, but part of my concern then is if we try to draw the line somewhere there, that is not what the commission said when it stated the law it was applying in this case, which as a result means it's quite possible they didn't make findings that might be relevant to the sort of test that we're describing. The commission wasn't trying to contemplate when deciding if something directly related or indirectly related, how impactful is the condition on that employee's life before the accident? Were they compelled to seek treatment no matter what? Is it something where they are compelled to seek treatment but they might have had different options? All these different factors that you might consider to decide how direct is that relationship. And so there's not a record if we were to adopt a test like that for us to apply it. If that's where we end up, what would you suggest we do?
Well, I think there is a record. I think findings of fact 23 and 24 support that. And in his deposition on page 22, line 19, Dr. Barrier testified, and this is the question and answer. I think this is where that finding of fact 24 comes from. Absent a need to have the total knee replacement, in your opinion, would Ms. Kluttz-Ellison have to lose weight? In other words, is it a requirement that she lose weight absent the need for this surgery? And the doctor's response was, she wouldn't have to. Now, he then goes on to say, it would be healthier if she did, which I don't think any physician is going to disagree with, but she wouldn't have to. And so that is where we get to the question of, is the workers' compensation injury the reason they have to have this treatment? In the cancer setting, in the hypothetical you gave, the cancer needs to be treated whether or not the surgery is done or not. But in this case, the weight loss, while it might be advisable to, it might be healthier to, does not have to be treated but for the need to have this surgery. And I think that is the line that the Court of Appeals was going down, and that the but-for test they said was, look, if this is not a situation where my client was injured and after her knee injuries said, I need to lose weight, just give me the weight loss surgery. That's general health insurance. She testified at the hearing that the only reason she wanted this surgery was to treat the knees. I don't think this was the kind of thing, prior to the knee injuries, and I think, it seems a bit to me rudimentary. I do agree that there were comments in the record about 75% being diet, 25% being exercise and lifestyle. But with someone who needs not one, but 2 knee replacements, the concept that condition, where one existing knee replacement is now loose, wobbly, and needs to be put back together, and the other knee needs to be replaced in its entirety, to argue that that individual is not at some kind of disadvantage in terms of weight loss, in terms of exercise, in terms of cardiovascular health, is a bit beyond the pale. I think that association is pretty easy to draw, and that inference is easy to draw.
What about, one other, and again, I'm trying to imagine all the different ways that we could try to create a standard here, because I have concerns about an issue as important as this, having the standard be just connect the dots, which I think is something that is going to, the Court of Appeals is going to struggle with how many dots can you have, how do you connect them, and that sort of thing. But suppose you had a scenario where we said, we're looking at if there's a pre-existing health condition, we're examining what were the options to address that health condition before the workplace injury, and then trying to have some standard that says, what options might you have had, what would a reasonable, prudent person have chosen to do in some of these scenarios, and that way try to have the direct or indirect based on how how things changed because of the workplace injury. And then, so you would need some evidence to say, for example, in an obesity scenario that, there's just this is not someone who would have been qualified for bariatric surgery because it was, there are risks involved, there are life-altering circumstances can come from it, and it wasn't necessary, but then this happened, and that gives you the direct relationship, versus if it's just, we think it's safe to do it if we lower your BMI. So we have to do that surgery first, that's sort of more indirect. But do you see, could that work, or do you think that's just?
I think it's more of, does the workplace injury now require it? And I believe it was Dr., and I'm sorry, Maliko or Maliko, it depends on, but I think he said, look, at this point, this is the only way. She's tried other things. She has tried, and counsel noted she had lost some weight during this because she was trying. She needed the surgery. And Dr. Maliko required some weight loss effort before recommending the gastric bypass. But and it's reflected, I think, in finding of fact number 23, which is supported in Dr. Maliko's deposition. He says, at this point, this is the only way. This is the only way she's going to achieve this amount of weight loss. Gastric bypass is the only way she gets to a 40 BMI to have this surgery. And I think that's also, proof in the pudding. She had the surgery after she finally got to a point where she could, and once she achieved that weight loss, had the total knee revision. And absent being able to do that, she would never have been able to treat this injury. And again, I think it's in drawing that line, I think the court has to be cognizant of who is tasked with applying that test. And that directly related, whether or not something is directly related under 9725 is the sound discretion of the Industrial Commission. And applying that test, it is a test for the commission to apply within their discretion and not subject to review absent an abuse of discretion. And when they find there is this reasonableness between the two, when they find as fact and supported by the evidence that but for the knee injury, she would not have been required to undergo the surgery, then they've met that standard, in my opinion, Your Honor.
If the evidence in the record were to indicate that her general health insurance would have paid for the bariatric surgery prior to the knee injury, would that be a factor to be considered?
Chief Justice, I think it could be a factor to be considered, but if they would have paid is a different question than if it would have been required.
Well, if they would have paid indicates medical necessity. So I have a hard time seeing the distinction between required and medical necessity.
I think the necessity, I think we're using the word slightly different. To say that an insurer would have paid is medical necessity as required by their policy. I think that is different from a doctor saying, you've got to have this done in order to have this surgery. I think those are slightly different issues in my mind. I hope that answers your question. I think medical necessity as defined in an insurance policy is slightly different than a doctor saying, you got to have this treatment or you're going to die, or you got to have this treatment or you can't get this fixed.
Well, but what it does indicate is that it's a general health risk such that the insurer should cover the medical care. Would you agree with that?
I would agree that obesity can be a general health risk, Your Honor. But I also, under the facts of this case, while she had this condition, she was not being required, it might have been advisable, but she was not being required to treat it. And I think that's where the commission sort of hung their hat of saying that, yes, this condition existed. I mean, we know that the plaintiff had a BMI over 40 prior to this accident. But there was no requirement that that BMI be treated except for the need to treat these injuries. And the testimony is pretty clear on that in Dr. Barrier's testimony. Again, he says, absent the need for these surgeries, she would not be required to lose weight. Again, answering this question in Ms. Kluttz-Ellison's favor does not turn the Workers' Compensation Act into general health insurance. It does not, as long as this direct relationship standard is applied, change the act from doing anything other than treating a compensable injury. And again, the alternative would be, particularly in the uninsured setting, having an individual injured at work, needing treatment in order to recover from that injury, and not being allowed to get it. And that simply...
To the extent that is your rationale, doesn't it call into question the distinction that you tried to draw in response to Justice Stietz's chemotherapy hypothetical? Because in that situation, the worker wouldn't be able to get the treatment, and the employer would be relieved from the obligation to cover the treatment.
Justice Allen, if I understood the question correctly, I think the chemotherapy, the distinction I was drawing between the congenital heart condition hypothetical and the chemotherapy hypothetical was that the reason for treating the heart condition in the first hypothetical is to have the surgery. In the second hypothetical, we have a condition that requires treatment with or without the need for surgery.
But in that second hypothetical, then you would say, well, even though the result is that the employee can't obtain treatment for a workplace injury, too bad.
No, Your Honor, I wouldn't say too bad. I would say under that scenario where the reason for getting the chemotherapy is not because of the workplace injury, then it is not the employer's responsibility. Because now then we would be, I think, venturing off into general health insurance, saying that now that it's worker's injured, you've got to treat any condition, whether or not it's related in any fashion or in a direct relation to the compensable injury.
I just want to be clear. So in that situation, you would say, even though the employee is entitled to treatment for the injury, and the employer clearly would be liable for that treatment for the injury, the employee would have no recourse.
No recourse where the need for treatment is not, where the treatment is needed outside of the setting of treating the compensable injury. That's not, the facts of this case are that the doctors testified, the commission found, that but for or without, except for the need to treat her compensable injuries, the obesity would not be required to be treated. In the setting of the chemotherapy issue, the cancer issue, I would assume, under the hypothetical, that that condition requires treatment with or without the work-related injury. That's not the case here. The doctors testified that but for the work-related injury, she wouldn't have to have this weight loss surgery.
No, I understand that. I just wanted to be sure that I am correct in thinking that, in your view, in the chemotherapy hypothetical, the employee would just be out of luck.
I would not phrase it that way, Your Honor. I would say that the workers' compensation carrier would not be responsible under that hypothetical, where the underlying condition required treatment without regard to the work-related injury.
So then I take it, though, you do agree that if it was a rare congenital heart condition and that needed some experimental procedure in order to engage in some rather routine workers' compensation surgery, you know, orthopedic surgery where you shouldn't, it's not safe to do the anesthesia until, you know, on somebody with this condition, you would say the carrier, the employer and the carrier will pay for the experimental heart procedure.
If it was not, if it was.
Right, because you're living fine without it.
You're living fine without it.
You can't have some sort of surgery because you can't go under anesthesia, let's say. It's too dangerous if you have this heart condition.
Yes, yes, Your Honor. I mean, because again, and I think that is what you said, because you were living fine without it beforehand.
Right. I mean, what we're describing makes a lot of sense to me if the test is but-for causation. I think what's odd is that's not what the courts chose as the test. We said directly related. What I'm struggling with, as you can probably tell, in this whole case is what are the indirectly related ones? You know, it just seems like if what we just do is reduce the test to but-for causation, we're just overturning a whole long line of precedent and creating an entirely new test. And so directly related must mean something, and there must be another category that are more indirectly related, and there's some sort of a line.
Well, the Court of Appeals said, and this is one line that sort of stuck with me out of their opinion, is that while the existence of the plaintiff's weight problem was not directly related to the accident, the need for bariatric surgery was directly related. And I think that's a distinction that makes a difference, that they're not saying that the obesity is directly related. They're saying that the treatment is directly related. The need for treatment. Is the need for treatment necessary to treat the workers' compensation injury? And I think that's the but for. But for this injury, would she require this treatment? So not but for this injury, would she have this condition? But for the injury, would she require the treatment?
Counsel, under 97-2 sub 6, injury does not include a disease in any form, except where it results naturally from the employment, or naturally from the accident. Why wouldn't a dividing line here be that a disease in any form, not naturally occurring or related to the accident, or related to employment rather, it shall not be considered directly related? Let me rephrase that. If you have a disease in any form, right, that's not naturally occurring and naturally related to your employment, then it's not compensable. Why would that not apply to the directly related test that we're trying to come up with?
If I understand your question, Justice Berger, I think the distinction here is that we've proven that injury under the Workers' Compensation Act. This is an injury by accident case, and the underlying knee injury is the injury. And that's where I was talking about earlier. I think the defendants are sort of mixing concepts. We're required to show that the accident caused this injury. We have done that, and it is not disputed. Then the question becomes, what treatment is directly related to treat this injury? And the answer to that in this case is, but for the bariatric surgery, she cannot be treated.
Right, but if it's the injury, right, the injury doesn't include the disease in any form, right? So why should treatment include disease in any form?
Because I think you're using the definition of an accident under the statute, or definition of an injury under the statute. And because we've already shown that the underlying injury was caused by the employment. And then, once you've done that, are we going to treat the knee injury or not? What treatment is required?
Right, and I apologize, I know I keep talking around this, but if the injury cannot include a disease in any form, right? How can treatment of the injury include a disease in any form?
Counsel, your time's over, but I'm going to allow you to answer that question, and I'll give your colleague the same time that is required for that.
Thank you, Chief Justice. Because, again, if I'm trying to address the question if I understand it, because the accident caused the need for the treatment. Because I think what the drafters of the act at that point are trying to do is say there's got to be some injury. There's got to be some injury for this claim to be compensable under the Workers' Compensation Act. Once you've proven that, I don't think that same standard applies to what treatment is required. 9725 just blatantly says medical treatment shall be provided by the employer without any further explanation. The courts then have said that treatment must be directly related to the original injury. If the court has no further questions, we would ask you to uphold the opinion of the Court of Appeals and find that the bariatric surgery is directly related to the compensable injury and required to be paid by the defendants. Thank you.
Thank you, counsel. Rebuttal, and it appears you would have a minute and 20 seconds additional time.
Thank you, Justices. We're not trying to create a new standard or a test. Every case that uses the phrase implicit in the authority of the Industrial Commission to order additional medical treatment is the requirement that the medical treatment be directly related to the original compensable injury, and it's followed by a causal relationship discussion and analysis. The Court of Appeals cases, Parsons, Pittman, Peeler, Perez, all state that the medical treatment must be directly related and proceed with a causation analysis. Causation is defined in those cases as the workplace injury causing the need for that treatment. So there's a direct causal relationship. Even this court in the Wilkes v. City of Greenville case in 2007 viewed proving additional medical treatment directly related to the compensable injury as proving a direct causal relationship to that injury. So here what we have obesity. The obesity is causing the need for the gastric bypass surgery, not the knee injury. The knee injury did not cause her obesity, did not cause or aggravate her obesity. And that is a pre-existing condition for which she actually treated for and did need and require treatment. She was placed on a prescription for phetamine. Her doctor, Dr. Barrier, said that she had been struggling and needing medical help for her weight loss. So this argument that there was no requirement for her to seek medical treatment before until after the injury is not with the facts in this case. She did seek medical treatment for her obesity, and the workplace injury did not increase her obesity. It did not make it, there is no direct causal relationship between the workplace injury and her obesity. And that is where the Workers' Compensation Act will extend out into general health insurance if there's no causal connection to that original injury, which is her right knee injury.
Will it be transformed into general health insurance if we adopt the standard that your opposing counsels advocated, namely that, as I understand it, that a procedure is covered if it wouldn't be necessary but for the workplace injury?
Yes, it does, because when you use a but-for standard, indirect causation falls under that but-for analysis. And so you are paying for medical treatment that is not directly related. And the case law previous has stated implicit in the authority for the Industrial Commission to award medical treatment is that it has to be directly related. So a but-for adds an indirect element, and it adds confusion and an unworkable standard. We have a workable standard that continues with the principle of the Workers' Compensation Act in that it needs to have causation, and the injury had to have caused the need, and here it's absent. I believe, oh, sorry, no, I still have some time. Also, I wanted to point out to the justices that actually her general health insurance did pay for her gastric bypass surgery, and that's how it was provided previous to the ruling of the Court of Appeals. And I believe that there was a mention of a root canal issue and hypothetical using the but-for standard that my colleague would like the court to adopt. If you have a root canal and it's infected and then they have a workplace injury that they need surgery, well, the employer now has to pay for that root canal to get fixed and the infection before they can have the surgery. That, again, is outside of the Workers' Compensation Act.
As I understand the argument on the other side, if it's an injury that has to be treated anyway, then it's not, it doesn't fall into the direct causation. So that's why chemotherapy won't be paid for, and if you had an infection that you needed treated anyway, that would not be covered either.
And I understand that. I think it also would fall under, it's not related, directly causally related by the workplace injury. And I think that's the standard that's already been founded in our previous case law. And so we don't need to make a new standard or have a tenuous connect the dots, because as long as the dot before caused the injury, and what is being treated by that treatment, then it falls under Workers' Compensation Act. And in this case, Ms. Kluttz-Ellison already was treating, and there was a need. Dr. Commodore testified that her weight would eventually kill her. There was a requirement here for her weight to be under control, but that's not under the Workers' Compensation Act. And the fact that her high BMI that was alerted by her, sorry, I believe my time is up.
You do have another minute if you would like it, and you could respond to the question.
Okay. Just because her, the surgery was prevented by this pre-existing condition that she had tried to treat beforehand and was unable to treat her obesity until a doctor suggested gastric bypass surgery, does not mean the employer now is responsible to treat her weight issue and her weight problem. It's not directly caused by the workplace injury. Thank you. I appreciate it.
Thank you, counsel. Thank you both.